All right, so our fourth topic is one that's near and dear to all of our panelists' heart. I was sort of surprised at how much response this particular topic got, but it's about partners as plaintiffs in employment discrimination litigation. So Betsy's going to lead off on this one, and Wayne will make a brief rejoinder.
And I also know in our audience there are at least some of you who are in the HR field at law firms, so you may find this of interest as well. So how does this topic come up? What's the legal context for it? Well, as you know, what we deal with in the discrimination area are laws that protect people who are employees. And the reason that there's the special brand of cases or special area involving partnerships is that an argument has been made, and successfully in some cases and not successfully in others, that partners of a law firm in particular, but it could be an accounting firm or another professional organization, are not employees. You wouldn't necessarily think that that would give rise to a lot of dispute, but it does, and it has over the years, because the statutes, Title VII and the ADEA really have only a circular definition. An employee is someone who's employed by an employer. That's very helpful. I don't know who thought of that one, but anyway. So one of the cases that first addressed this issue had to do with someone being promoted to partner, and in the case went to the Supreme Court, Hishon versus King and Spalding, and it was about it became a famous case because they talked about having a wet T-shirt contest during the summer program involving associates. That was one of the pieces of evidence of gender discrimination. But a luminary, a former president of the American Bar Association, Justice Powell, who was on the Supreme Court, in the context of that case said the following: "The relationship among law partners differs markedly from that between employer and employee, including that between the partnership and its associates. The judgmental and sensitive decisions that must be made among the partners embrace a wide range of subjects. The essence of the law partnership is the common conduct of a shared enterprise. The relationship among law partners contemplates that decisions important to the partnership normally will be made by common agreement." So just a statement of philosophy back in 1984. Today, both the EEOC, in cases that they are seeking to litigate involving mandatory retirement ages at law firms, as well as many individual partners who choose to sue the law firms that they formerly worked at or have disputes with, has been chipping away and trying to set sort of some standards that would apply in deciding whether these laws apply to partnership decisions. And a lot of the press attention came in about 2007 when a lawsuit was filed by the EEOC in Chicago against the firm of Sidley and Austin, a major international law firm that had stripped its firm of a number of partners at the time. And what developed, and that case ultimately was settled, so there was never a final decision. But what we've had over the decades, I would say, are sort of two developments. One is that people are less reluctant to sue a law firm. I mean, 20 years ago, this just would never happen. And today, it is much more commonplace. So, this is something to think about and be focused on, is whether it could happen to you or your firm. The second development is in the law, and what we now see is that there have been cases that involving small professional organizations where, at the end of the year, the partners sat around a conference table and decided how to divide up the profits. I mean, that type of organization. And those have consistently been held to be true partnerships, if that's the right word, and not employees, that the partners in those organizations are not employees. The EEOC argued that Sidley and Austin was a very different kettle of fish because it was a huge organization. It was run by a management committee that was self-perpetuating, that the partners in the firm really were more like employees because they had very little say in the operation of the firm, and so on and so forth. But often the facts are not that stark in one direction or the other, and what we have very little definitive guidance, but there has been some decisions that give us at least a clue as to what courts will look at factually, and they will look at issues like how the firm is governed, how people are treated, and also the independence, because partners in law firms tend to operate somewhat differently than an executive or manager or director in a corporate setting. They don't really have bosses telling them what to do or telling them how to handle a matter. They operate very independently. So I think we will see cases in the future. I think we will see more cases dealing with issues of gender discrimination, age discrimination, people who've been asked, to stop working because they're no longer making a contribution, issues of compensation potentially, people who think they should have been promoted to partner and were not, has always been an issue that's more like an employment case. But as many of the people sitting on this panel know, these cases create a lot of unique problems and issues for the people on both sides of the case, because there's an interest often in confidentiality. There is a lot of difficulty involving the information that is not public in any sense of the word, that becomes relevant in the case. And these are often difficult situations to resolve, and therefore present, I think, for the litigators, unique challenges. It's an interesting question. We had this debate a few minutes ago about litigation versus arbitration, and many law firms try to address the issue of this potential for litigation with their partners by having an arbitration clause, and I don't think it's the kind of clause that could ever be attacked. When you become a partner, you sign a partnership agreement that says you're going to arbitrate your claims. I think that's one that's going to be enforced.
Thank you. Wayne.
Well, Betsy ended on a note that I can agree with. I think an arbitration agreement and a partnership agreement will be enforced. It's not surprising that this development has occurred for a couple of reasons. One is demographics, and the other is the growth in the size of accounting and law firms. On the demographic side, you've got a lot of people like myself, baby boomers, who just want to keep practicing law. We don't want to leave at 65 or 70, yet employers, law firms, have young people coming up through the ranks who want to get promoted to partner, and there's pressure, and there's economic pressures, and they're sharing the pie and all those things. So it's not surprising in the category of age that there's this tension between equity partners who want to stay and law firms who want to push out some of them. The other is the growth in the size of institutions. Over the last 20 years, the law firms have grown. At this point, DLA Piper, I think, has 4,000 lawyers around the world. Accounting firms have gotten fewer and bigger, and the very notion that a partner at Ernst & Young or at Deloitte & Touche or at DLA Piper is necessarily a real partner is obvious in stating the proposition. It's not, that person oftentimes is not a true partner. This is an example where every once in a while the courts exercise common sense. And even even the United States Supreme Court in these days has exercised some common sense. In a case about 8 years ago called Clackamas, the Supreme Court recognized that just because somebody has the label of partner does not mean that they are a true partner. They may in fact be more like an employee than a partner, and therefore as an employee should be given the rights that employees have under the anti-discrimination laws, particularly with respect to age discrimination and sex and race discrimination. So basically what the courts have adopted, and this is, the EOC has issued guidance along the same line, is that there's a multi-factor test to be applied. I won't bore you with the details of that, but looking at the indices of this relationship. Is this person a true partner? Do they have control over their work? Do they share in the profits? Do they share in the risks? How much say do they have to say, in the governance of the law firm? And court will look at these factors and say, even though this person has the label of a partner, they're not a true partner. They're really more like an employee, and therefore they're entitled to the rights of an employee. And that's a common sense approach.